Well, good morning, everybody. My name is Roel Schuller, and I'm a professor here at UC Hastings. I have the privilege of moderating our first panel, Regulating 3D Printing, How to Impose Limits on the Theoretically Limitless. Of course, the most pleasurable part of moderating a panel is introducing our panelists. And so that's what I'm going to do now. And I have to say it is an incredibly humbling experience, sort of reading the biographies and just the life experience of this panel. Again, makes me wonder about my own qualifications to moderate at all, although I guess I have more of a qualification to moderate than to talk substantively about these fascinating issues. So let me start, and I'm going to keep these introductions brief, which doesn't do credit to all the amazing accomplishments of the panelists that we have. Immediately to my left is Keith Murphy. Keith is a biotechnologist. He is the co-founder and CEO of Novo, which is the country's leading biotech company, leading in the use of 3D bioprinting technology to create human tissue through the 3D printing process. Prior to founding Novo, he was the director of process development at Amgen, as well as a variety of other functions at Amgen. And he is also the vice chairman of the Alliance for Regenerative Medicine. To his left, we have Andrew Hessel. Andrew is a geneticist. He is a distinguished researcher with Autodesk's Bio-Nano Programmable Matter group. That's the group that designs software that is itself used for designing living and nanoscale systems. He's a professor, or was a professor of biotechnology and bioinformatics at Singularity University. And in addition to his research, he writes about genetics and technology. Next to Andrew is Kai Peters. Kai actually has the most distinguished credential of any of our panelists. He is a graduate of Hastings College of the Law. He is a partner at Gordon & Reese, specializing particularly in representing pharmaceutical, medical device, and other FDA-regulated companies, as well as other high-tech businesses. And last, but certainly not least, is my colleague, Marsha Cohen. She is a professor here at Hastings. She teaches and researches in the areas of administrative law and food and drug regulation, as well as torts. She has many expertise, but for today in particular, she is an expert on food and drug law. She's served on so many government advisory committees that I'm not going to list them all. I will point out, I think, what is the most relevant of them, which is the FDA's Device Manufacturing Practices Advisory Committee, which she has served on. So those are our very impressive panelists. Let me explain how we propose to proceed. Our panel has particular expertise on 3D printing of medical devices and technologies related to medicine, as well as other pieces of biotechnology. So I think what we'll do is start with that regulatory regime as a kind of a model for thinking about how you might regulate the 3D printing more generally. But I hope that we'll widen our inquiry into a broader range of products that 3D printing might ultimately allow. What I'm going to do is ask Keith and Andrew to start off by talking briefly about their work, about the specific products and potentialities of 3D printing that they're familiar with. Then I'm going to ask Marsha and Kai to briefly discuss the existing regulatory regimes for medical devices, the regulatory process through particularly the Food and Drug Administration. Then we'll return to Andrew and Keith to discuss their views from the sort of side of the producers of 3D printing products, of interacting with the regulatory regimes, as well as the technical and ethical issues raised by the technology as it exists now, and how they envision it, as they envision it developing over time. Then I'd like to spend some time discussing with the panelists not the sort of regulatory steps, the extent to which the government is restraining this technology in some ways, but to continue on Charles's ideas here, how it is that the government can take affirmative steps that would promote the development and use of 3D printing technology in ways that are socially useful. And then we have a nice big chunk of time today, so then I know we'll have a chance to open up the floor for questions, which I really look forward to hearing. So that's the plan, and we have this podium, but I'm actually going to invite us all to be sitting down, I think, unless anybody has any particular preference to come up here, and that will include me. So let's start. Keith, why don't you start, and then Andrew, just to talk a little bit about the actual product.
Yeah, let's talk about the technology a little bit. So Organovo specifically does 3D bioprinting, and that basically constitutes the creation of structures out of cells. So we take what we call a bioink. That's our starting point. We can take any number of different cell sources. You can actually think about taking a biopsy from an individual person. Usually, though, you will have to replicate those cells, duplicate them, grow up a number of cells to make enough ink to work with if you take a biopsy. You can take a cell line that's been in a research lab. You can take a stem cell population, for example, from one's bone marrow or adipose tissue, fat tissue. We have ample stem cells in those, and they multiply quite well. That's our starting point, and we will create this bioink that is basically an input into a system that allows layer-by-layer deposition of the materials to create a larger structure. So 3D printing in general, the reason it's called printing is largely because we work layer by layer. So you wouldn't, if you were creating that whole object in a flash, you wouldn't think of it as printing, but the reality is we call it additive manufacturing. We layer things up. So you start with a cross-section of the overall computer design, and then you're going to print each layer on top of one another in sequence. And in the case of 3D bioprinting, each of those contains cellular building blocks. So we will have made these cells into a bioink that is largely a cellular building block, and I consider that to be a little bit like making something out of Legos. So if you think about that anatomical structure, that anatomical model in a physician's office that you'll see made out of plastic and showing a cross-section of a tissue, if you think about making that out of little tiny Lego blocks yourself, perhaps with your kids, but instead now think about it being much smaller and made with a machine doing the deposition of each block in place. And instead of printing a colored block in a certain position, you're putting a block of a certain cell type in a certain position, because really all of this material ends up looking like white opaque material in the end. None of it has those fancy colors that we see in these anatomical models. So that's how we build up a structure, and we've made things that range from very simple thin 3D tissues to the most complex things. We'll make our 5-centimeter long blood vessels with multi-layer structure. People often start to ask, well, can you make a full liver? Can you make a full kidney? And going, can I get one? How fast is that going to happen? And we're not there yet. One of the big challenges is continuing to work on this vascularization side, making blood vessels so that you can feed all the cells inside a larger structure. One of the challenges is reproducing the vasculature that we have in our own bodies. Every cell is being given oxygen constantly by a perfused flow. We're working at a scale where we can rely on diffusion to feed the cells. So we have a media of nutrients, and that media contains oxygen as well. The cells can get oxygen and nutrients simply by diffusion, so we can make things on the order of a 0.5 millimeter to 1 millimeter today, and we're working on ways to do the blood vessel structure to go larger over time.
Great, thank you. Andrew?
Good morning, everyone. I'm with a company that you may have heard of. It's called Autodesk. It's actually one of the largest companies in the design and engineering software space. It's actually been around for over 30 years. It typically hasn't been a mainstream company. It's largely business to business, because our clientele were people like architects and designers that put up buildings or manufactured cars or major products. There's been a shift in the company over the last 5 years, though, because computing's gotten very cheap. Being able to scan objects with lasers and even photographs these days that extract design information has gotten very inexpensive. And 3D printing, which has opened up manufacturing to a community of individuals and makers that just didn't have access to the technology before. 3D printing isn't new. 20 years ago, I had friends that had 3D printers in their workplaces because they were doing product design or making props for movies where it was just too expensive to get anything mass manufactured with molds. So, but the combination of having inexpensive software tools and a way to translate the designs into a 3D structure inexpensively and accessibly is quite new and disruptive. So Autodesk has seen an amazing explosion in its customer base, moving away from, I think in 30 years of business, we had 12 million professional customers. In 5 years of kind of approaching makers, we have something like 150 million consumer users now. So we're seeing this dynamic explosion. So that's interesting. I'm not, although I see 3D printing every day. We have a whole facility down at Pier 9 that is kind of a big maker lab. I'm a genetic scientist. I actually look at the design software of, I've used design software for genetic code for most of my life. It's really not easy to work with. And the 3D printer is actually a cell. Load the code into the cell and you will end up reprogramming the cell to do some very useful things, perhaps work in your printer, perhaps make a drug. So I'm actually looking at nanoscale 3D printing, so to speak. I think that'll be disruptive. Here's just a little model of a 3D printed virus, but it's technically pretty much the same process to make a real virus. Anyway, I'll leave it at that.
Great, thank you. So now, I guess Marsha and Kai, we'd like to address the regulatory regime that exists that if you use 3D printing or if you use any system to create a medical device or some kind of pharmaceutical, has to go through a regulatory process. And I guess what we talked about doing is Marsha maybe describing just briefly again the overview of that process, and then Kai discussing some of the problems that manufacturers can get into when they're interacting with this process, in what ways it, particularly in dealing with novel technologies and new types of medical devices.
Okay. My role here, as Roel said, is to, at least initially, to give you the quick and dirty overview of the regulator who's watching with great interest, we know, as 3D printers move from industrial and workplace uses where they are essentially functioning as manufacturing tools, making product parts, homes where they're making toys and models and things like that, and potentially guns, which we'll talk about this afternoon, to making items used in human health, and even with the dawn of what's being called bioprinting, pieces of humans, or maybe entire humans. In fact, Keith here, who is the president, CEO of Novo, might have to leave because he and his wife are about to welcome their twins, you know, one real and one bioprinted.
You're on to our secret.
They're the first. So in any case, the regulator is the Food and Drug Administration. It has statutory authority to regulate what are called medical devices. Now, medical devices are defined in statute under the Food, Drug, and Cosmetic Act, under Section 21 U.S. Code, Section 321H. In pertinent part, a medical device is an instrument, apparatus, implement, machine, contrivance, implant, in vitro reagent, or other similar or related article, including any component of the above, intended for the use in the diagnosis of disease or other conditions, or in the cure, mitigation, treatment, or prevention of disease, or intended to affect the structure or any function of the body, and which does not achieve its primary intended purposes through chemical action within or on the body, and which is not dependent upon being metabolized for the achievement of its primary intended purposes. This latter part of the definition, obviously attempting to distinguish a medical device from a drug, that's another category subject, as you, I'm sure, know, to regulation by FDA. The world of medical devices is gigantic and incredibly varied. I assume probably that all of you have already used one today. Your toothbrush is a medical device, or probably lots of you have one on you, your contact lenses, and you've come in contact with many of them in your routine doctor visits, and otherwise, and in labs, etc. So they can be simple, or they can be quite complex, things like heart-lung machines, replacement hips, and the many amazing devices now used in surgery. You've probably heard of robotic tools and laser scanning things that are used, as well as life-saving devices. I suspect there is an automated external defibrillator somewhere within a few seconds' reach of where we are sitting and in many public places. These are all medical devices. Until 1976, there was actually no statute that specifically gave the Food and Drug Administration authority to regulate these. Even though they had authority to regulate drugs, basic authority from 1906, much more complicated and specific authority from 1938. So it was a long time before they were recognized by the US Congress. For a long time between 1938 and 1976, the Food and Drug Administration would engage in some creative utilization of its power to regulate drugs to require that products we now clearly call devices had to be safe and effective before marketing. It won a number of cases in court calling some things that we clearly now would call diagnostic devices drugs because there was a burgeoning supply of these, and they were not being regulated. In 1976, the Medical Devices Amendments to the Food and Drug Administration passed, and we now have a regulatory scheme. It's one of significant complexity, unsurprisingly, as it has to deal with this broad range of items. And what it does at the most simple level is divide them into three parts, like, Olive Gall, right? Divide into three parts, three classes, and only class 3 devices, those which are used to support or sustain human life or are of substantial importance in preventing impairment of human health, or present a potential unreasonable risk of human health or injury, of illness or injury, that's the definition, must in most but not necessarily all cases obtain pre-market approval to provide FDA with what's required, which is reasonable assurance of their safety and effectiveness. It's a slightly different requirement than with drugs, which have to be proven to be safe and effective. This is reasonable assurance of safety and effectiveness. In contrast, class 1 drugs are things like, the toothbrush or even the electric toothbrush, things for which so-called general controls, things like complying with good manufacturing practices, are sufficient to provide that reasonable assurance that they'd be safe and effective. Class 2 devices in the middle need special as well as general controls. What are they? They're things like performance standards, post-market surveillance, registries of patients, compliance with various guidelines. So there's a huge world divided up. Probably only 5% of devices, certainly no more than 10%, are subject to class 3. Okay, so it's a small subset. Now, the law has been changed a number of times since 1976. Congress never gets it right the first time, right? So there have been changes. When initially adopted, of course, there was the problem of transition. There were a lot of devices that were being marketed at that time, and they had to consider, what does FDA do with all those products that are already out there? One of the concerns that the Congress and industry had was that if you were already marketing a product, even if it was a complicated product, and what about others? What about competitors? And other people said, what about us? If we have to do a lot more to get on the market than people who've already been out there just because they're out there, that gives them a basically non-patent protection for when? Forever? So the FDA actually took a piece of its statute. It says 360K, but it's known by its Food, Drug, and Cosmetic Act number 510 as 510K. You will hear that in medical devices constantly. This is called the 510K process. It's based on this statute. It is absolutely not immediately clear when you read this section why this statute has anything to do with what actually it does. I see one of my students smiling over there because she had to read this yesterday. On its face, it says if you're required to register as a producer of devices, you need to report to FDA 90 days before introducing to market one of these devices. the class in which it's classified and how you're complying with the requirements for that class, for that device. Okay? What's come of this is FDA interpreted this broadly early on and said, aha, well, if you want to market a device, you're a new entrant, but you're making a product similar to something that's already on the market, you could just give us a notification under 510K, and we will consider this sufficient if your device is substantially equivalent, that's the term of art, to a device that is already on the market. That device already on the market is called a predicate device. And if you're substantially equivalent, then basically it's a safe harbor for this 510K process. Now, this process has gotten somewhat more complicated than it was at the beginning, but also many people believed that this was just a transitional process to take us through this time when we had people coming in and making things that were substantially equivalent to things that were there before 1976. But it is 2014. This process is still used, and you can use it to demonstrate substantial equivalence to a predicate device, which may have been substantially equivalent to another predicate device, which may have been, and you get the picture all the way back to the beginning. You're no longer required to be substantially equivalent to something that was on the market back in 1976. Now, we could discuss all of this at length, but we won't. We'll cut to the chase. You're probably getting the idea that there is a lot of room for lawyering in this field to get you into 510K, for instance. But in the area of these 3D printers, we really have to ask, what's the device? Is this the device? That is what a 3D printer that you can go online and purchase right now, and it will be delivered to you probably in 2 days. Is this the medical device? Now, this looks like it's showing us making some kind of troll. And this is not a bioprinter. So if this can make auto parts or toys out of plastic, well, FDA wouldn't care. But it's probably also capable of making things like plastic splints, crutches, tubing that's used in hospitals, things that are used around doctors' offices. That is, this one machine can obviously make a lot of different products, only some of which meet the definition of medical device. So that asks the question, does the maker of this product have to worry about the Food and Drug Administration? But maybe it's not the machine's maker, in any case, which is the producer of the medical device, any more than the makers of the machines that are now in factories where they make splints and crutches and tubing for hospitals are medical devices. Maybe the maker of this, that's just some random code, the maker of the software, that is what FDA needs to look at. Because the instructions for the machine determine what the machine actually does. So perhaps that looks like, and it feels to me like that should be the appropriate focus of the FDA's attention. Now, the FDA has been dealing with software. It has a number of guidance documents pertaining to software in medical devices. That has been an issue. Hey, software hacking in medical devices has even been a TV plot, as many of you know. So perhaps it is the software creators who are going to be subject to regulation as the device creators. That's, of course, if we're talking about 3D printers that are used to make things. What if we're talking about the new world, to Keith's and Organovo's world of bioprinting, of machines that will create things that are made out of human cells? Now, I hope all of you have checked the yes box on your California driver's license and agreed to be organ donors, and I hope none of us ever makes that donation. As you surely know, people are dying, literally, for lack of transplantable organs. The world of bioprinting ultimately might be around making things like human hearts. A wired UK piece from last November suggests this is only about a decade away. I don't know whether Keith agrees to that timeline, and that they'd use the recipient's own cells. You wouldn't have to worry about it being rejected by your body. The heart apparently is a whole lot easier to make than things like a liver. So it will be something out there. Does this change the analysis? I would imagine that the machine, if it has no functions beyond the medical world, would be something that FDA will be out there to regulate, as would be the software. Now, I can also imagine that some uses of bioprinters, their makers might say, but we're not making medical devices, we're making cosmetics. This is purely cosmetic. Cosmetics are the least regulated of everything in the FDA's world. They are regulated, but barely. A cosmetic is something under the law that's intended to be rubbed, poured, sprinkled, or sprayed, or introduced into or otherwise applied to the human body or any part thereof for cleansing, beautifying, promoting attractiveness, or altering the appearance. If the printer just adds some fat and skin to erase your wrinkles, merely cosmetic. How does this differ from other things that are already being done? Subject perhaps to no pre-market review at all. But what about the organ itself? If we are making hearts and lungs and livers and kidneys and who knows what else, printed for medical reasons, FDA does actually regulate human tissue and organs now. There is, transplanted organs are regulated. If we were to focus on the organ itself, then the clever lawyers like Kai here, who are representing companies, are going to take a look at the section in the medical devices law on custom devices. In current terms, think of the things made for you or your children for orthodonture uses. They're made directly for them. They're fitted to a mold. They're also widely used dental implants and new teeth and whatever. They are made just for an individual purpose, and they escape most significant regulation. That obviously would be the route industry lawyers would like. I cannot imagine the most limited level of regulation for an implanted human heart. At least I hope. I come from a consumer group representation background, so I hope there's someone watching, even if they're made from your own cells just for you. And so I imagine the 3D printed heart would get some regulation, and I'd say, shouldn't it, after all? One question that will be raised by the industry lawyers is which corridor of FDA will be the regulator? There are two potential corridors. There's the Center for Devices and Radiologic Health, which regulates devices. There's also something called the Center for Biologics Evaluation and Research, or CBER. Industry generally has its preference for one center or the other, is always perceived in these combination products as being better for us. The rule when a product is a combination, a drug device, a biologic device, there are lots of these, is jurisdiction depends on the primary mode of action of the thing. And there is actually already an inter-center agreement that governs this decision-making. There is one between CBER and CDRH. They will undoubtedly, it's been in place since 1991. They weren't thinking about this stuff. Undoubtedly, they're going to have to think about this stuff. Now, in another sort of legal world, there are benefits to industry for getting to market via that less common pre-market approval path, even if the 510K route, if available, is likely to be considerably faster. The devices law passed with a preemption provision. By its terms, it suggests it was there for exactly the purpose it was put there for. A lot of states were regulating devices before the feds got into the business in 1976, and industry wanted and Congress agreed that the state regulation should be preempted after federal regulation, so they put in a statute that says essentially that no state standards should apply, there should be no state standards, and this has been interpreted by the courts as applying to tort litigation. So, if you are harmed by a medical device, and that medical device came to market by the PMA pre-market approval route, you are out of luck. The United States Supreme Court decided this. However, if it came to market through the 510K route, you've got a state tort lawsuit. So that is a huge difference from the consumer perspective. There's this huge differential. That suggests that there are some advantages to industry, ultimately looking down the pike at tort law, to taking a longer time period. The bioprinting firsts we're talking about today, certainly the firsts in the bioprinting firsts are going to be very unlikely to be eligible for the substantial equivalence route, though if you're 3D printing medical products that have been made before through traditional manufacturing methods, the 510K route would certainly, I would think, be available to you. Anyway, there's lots of other interesting legal issues that you can noodle around with in bioprinting, especially things outside the realm of saving lives. There's chatter about printing whole new faces for people, and at first my Food and Drug Law thought said, oh, what a wonderful thing for serious burn victims, for people who've had terrible facial tumors that have been excised. And then I thought, what about people who just want a new look? They want to look like a movie star, or they just want to not look like the old look that's on all, that's plastered in all the post offices. Anyway, this gives a whole new meaning to the words identity theft. And, of course, I also thought, wow, why worry about the face? It must be easier to do the fingerprints. So in any case, this is something else that the law is going to have to be paying attention to once the great scientists at Novo and other companies have things that they can make for us. And one thing we can be clear is that for the legal profession involved in this subset, the decades to come are not going to be boring.
So Kai, if you want to give us some examples of not boring, that would be great. Like what are the sort of some of the problems that in fact we've already seen?
Of course, and I do have some slides here. And so what I'm going to talk about again is a little bit about the heavy side of the FDA. You hear about how you have to get products to market, and and of course, as in real life occurs, there are people who don't comply, whether knowingly or unknowingly, and you see that across the spectrum. You hear it all the time. So what I'm going to talk about a little bit is what you might see happen, and I have some examples which are taken really from, I would say, areas that were new for the FDA. So first, here just generally, here's what the FDA does. Here's how the FDA comes into your life as a company. First, the FDA has inspection powers. They come into companies and they inspect. They look at how you're manufacturing. They look at how you're marketing. They look up and down the company. Companies don't like it when the FDA comes in generally. The best company in the world is worried that they may be doing something wrong. So after these inspections, and this is, I'd say, the mildest form of a rebuke from the FDA, it's called a 483 form. The FDA comes in, they look at what you're doing, they spend a few days there, they talk to your managers, they talk to your other people as well, and they come back to you and they tell you, okay, we've looked at you and here are the things you're doing wrong. Fix these things right away. And companies, almost every company takes those very seriously. Sometimes the FDA goes away, they say, we have no 483 form for you. Companies are very happy. Often they do have a 483 form. They formalize it in an establishment inspection report. So what's one level above that? Warning letters. The FDA may do a 483 form, and then they say, we want to take this to a higher level. And what they'll do, the FDA will then take it to a higher level at the FDA, and certain managers or supervisor, whoever, will look at this 483, see what the problems were at the company, and say, yeah, this warrants sending out an actual warning letter. Warning letters are sometimes public, and that's, of course, what companies don't like. They don't like their dirty laundry or their screw-ups being broadcast to the world at large. So that's a warning letter. And you'll see those go out quite a bit from the FDA as well. Level above that are enforcement actions. So a company gets a warning letter. They have the 43 forms, and they are not complying, or the FDA thinks you have not done enough. You're not paying attention to us. The FDA can go bring an administrative action and say, now you will comply, now we're getting the court system involved. That's the next level. The FDA has very strict powers as well, very potent powers. The FDA can come in if you are marketing devices or pharmaceuticals or anything which they feel does not comply, they can seize product from you. And sometimes they seize a lot of product from companies. They can also go to the court and have injunctions imposed. So the court tells somebody, you will not market these devices anymore. And companies, again, they take a lot more. You see how the regulatory regime and then the kickers really do have a lot of power to get companies to do what they're supposed to be doing. Again, the FDA can pursue civil money penalties, which can be very, very expensive for companies and result after years of litigation or years of enforcement actions. I think the highest level right now is about at $3 billion, but usually those get to the marketing side when people are making claims about their products which just aren't true, or the FDA says are not true. Then we get to criminal prosecutions. And that is something which companies have. The FDA has actually really I'd say about 2007, 2008, the FDA pulled out of its bag saying, we're not just going to go after the company, and we will pursue the company criminally, but we're going to go after the heads of the company too. And we're going to bring personal actions, criminal actions against them, and there are a few examples of that. There's an example of a company right here that's based in the Bay Area called Intramune. Another company where the CEO was actually prosecuted, went through the court system, and he actually is banned from engaging in pharmaceutical sales anymore. What they said was he was misrepresenting in press releases what their clinical trials showed for a certain drug. So those are some of generally the things that you can see as a company from the FDA. You also have civil actions. Don't want to spend a lot of time on it, of course. You've got product liability actions for products on the market. You have unfair business practices claims, class actions claims, patent infringement claims, a whole lot of claims that can be brought civilly as well. Now, I want to start out, instead of being just totally negative, on a success story. This is where the regulatory process really did work. We've got a product which is on the market now called OsteoFab, patient-specific cranial device. This is a device which is I'm going to say it in lay person terms, it's an implant for the skull. And what it does is, what this company did was they have, using 3D printers, printed out a portion of a skull to replace in a person. That's what it does. It has gone through the process. It is a Class 2 medical device. The company submitted its 510K in December 2012. It was cleared really quickly, February 2013. I don't know how long it took them to prepare their 510K, but I bet they were pretty careful with it. And no issues. It is on the market. This is a success story for 3D printing. And the FDA, although I talk a lot about the regulatory actions, the FDA actually does not want to be seen as an impediment to innovation. And there have been examples over the years, some of which have been involved, where the FDA actually reaches out and said, look, we do want to encourage what you're doing out there in industry. For example, virtual clinical trials. Clinical trials are how you get products to market. You have to prove first in animals, then in people, that these products are safe and effective if you're going the PMA route. So the FDA actually said, okay, we understand that usually for clinical trials, people have to go to a hospital and actually go there, and that was actually something which could be an impediment to having a broad enough patient population to test certain devices or pharmaceuticals. The FDA said, we want to encourage what's called virtual clinical trials, where these patient results are actually done over the internet and through smartphones. And they encouraged it. They worked with Pfizer to do it. I don't think that virtual clinical trials have fully taken hold. But again, just an example of the FDA does want to help, and they do want to put in place procedures and work with companies to make things happen. So now we get to some of the examples of where companies get into a little bit of hot water. This is a product which is it's called it's a urine analyzer, a U-Check urine analyzer. It's an app, a mobile application. This is something that the FDA has struggled with, and I think that the FDA came out with guidance on mobile applications just earlier this year, end of last year. That's one of the ways that the FDA tells companies, here, look, this is what we're looking for you to do. They're called guidance documents. They don't have legal effect officially, but they do help industry. So what this company did was it had this U-Check urine analyzer app. It also had strips, and what you do with these strips is that's what is analyzed, okay? The urine is analyzed, and it tells you if you're allergic to whatever. I mean, it tells you, gives you a readout if you're doing certain drugs, those kind of things. And the strips were cleared under the 510K process. The U-Check urine analyzer app, available on iTunes as of last April 26, 2013, was not 510K cleared, PMA approved. The company did not go to the FDA to ask, is this okay to put on the market? Well, the FDA sent a May 21st, 2013 untitled letter. I put warning letter, but up above I have untitled letter. That's something, a gray area. The FDA, people looked at it and scratched their heads, well, what's an untitled letter? They'll sometimes pull something out of their bag and say, you know, we're just sending this out. It's not a warning letter. But when you read it, it sure reads like a warning letter. And what analysts say is, and what they think is, the FDA, when they send something like that out, they're not quite sure of their authority. And the FDA, as we all know, especially lawyers in the room and business people, the people like to think that the law is clear. It's black and white. It's not. It's usually just gray. So they sent out this untitled letter, said, look, we think your U-Check urine analyzer app is a medical device under Section 201H, as Marsha mentioned. So we think you need to have this thing cleared or approved by the FDA. 510K products are cleared. PMA products are approved. And what the FDA did was when they sent this letter to the company, they said, and you know, usually they'll be very certain in what they say. You need this. What they did was they said, we request, give us the FDA clearance number, which of course they knew the company didn't have, and then said, or give us the basis of their position that no clearance is necessary. They were sort of generating discussion. I'll tell you what the company did. The company, according to the head of the company, took that product off of the App Store and put on the U-Check urine analyzer Lite, which took out the objectionable things, which purportedly could be used for health reasons, and then said, we're working with the FDA on that. That's sort of a light of what, not a very serious, it's serious, of course. Their product is gone right now, and they're working with the FDA. There are more serious things that can happen. Now, this is something many of you have probably heard of. It's 23andMe, especially here in the Bay Area. Now, the device at issue here is a 23andMe saliva collection kit and personal genome service, called sometimes for short a PGS. Now, what people do is they get their saliva, they send it in the company, and on the, I would say, mellow side of it, what they do is the company tells you where you came from. You are 50% Western European of German descent. You are 35% Czech or whatever it is, and they give you that information. But something else they do with this information is they will provide to you, or they don't do it anymore, but what they were doing was they were telling you if you are at risk for breast cancer, are you at risk for diabetes? That's the kind of analysis that they were providing to people based on these PGS, the PGS submissions. So the FDA sent a warning letter on November of last year. Now this is sort of definitely a heavy side of the FDA. And the FDA, I think, knew what it was doing when it sent this letter. It was not going out there and just picking on somebody. So what it said was, we think your PGS device is a device under Section 201H. It is, and the catchphrase, intended for use in the diagnosis of disease or other conditions or in the cure, mitigation, treatment, or prevention of disease. Well, if I send in a saliva test and somebody's going to tell me if I'm at risk for diabetes, yeah, I think somebody's probably trying to tell me if I am, that's trying to prevent disease or trying to mitigate some kind of disease or condition. And they said that the company, what it did, that it marketed it as a first step in prevention that enables users to take steps toward mitigating serious diseases, such as diabetes, coronary heart disease, and breast cancer. The assessments for genetic risk and drug responses were something that the FDA took issue with and said that there's a danger here. If you tell somebody, for example, that they have no risk for breast cancer and somebody forgoes treatment, that can have real repercussions for somebody. If you tell somebody that they have a risk for diabetes or some other condition and they go into doctors and they have floods of people coming in or a number of people coming in, those doctors have to do something about it. They have to do additional tests. So if that test is wrong, it can cost the healthcare system a lot of money too. So there are real repercussions. The FDA had a reason for going in. Now, what you see when you get a warning letter is you think that you could read this or see the news reports and think, oh, this was a sudden thing that the FDA did. The FDA just went in, found this company, and descended on them. That's not the case. And there's actually a history which the FDA sends out, and they don't always do this in warning letters. So the FDA, I think, was very hyper-aware that this would be this warning letter would get a lot of attention. Again, that's what they do with warning letters sometimes. They make it public. So what they did, some of the history here was, and as the FDA relays, that they had worked with 23andMe since July of 2009. So that is over 4 years before they actually sent out this warning letter. There's a lot of history there. The FDA said that they had worked with the company to analyze whether the devices were Class 2 510K clearance or if they could go under this other pathway, which Marsha didn't mention. It's called the Novo Classification, which are basically PMA products. There's no predicate device, but the FDA, again, showing how the FDA can come in and actually try to make things work a little more smoothly. This de novo process is one where you have something which would have to go through the PMA process. The company says, I'd like to go through the de novo classification process, and what that is it takes that product and says, okay, we understand you don't have a predicate device, but we also understand this isn't something that's going to kill people, or it's not really serious, okay? And so then they take that and they say, you can go through this de novo classification process, which is very similar to the 510K process, speedier, you don't have to submit as much information. So the FDA had worked with them on trying to analyze that. They had proposed labeling modifications for the company. They had had more than 14 face-to-face teleconferences with the company, hundreds of emails, dozens of written communications. The FDA provided feedback on a whole range of topics, on clinical studies, how to structure them, how to validate things. And then 23andMe actually did submit a 510K application, July 2nd, 2012. So then after that, they submitted apparently an amendment to that, September 4th, 2012. And the FDA, the 510K process can be speedy, but it can also not be speedy. If the FDA has questions, and Marsha mentioned it is a 90-day process if it all goes right. And that's what I showed you, the one that went the way you want it to go. But the FDA, if it has issues, it will send you a letter. And then it starts to take a longer time. And that's when you see companies get bogged down from their perspective in regulation. So the FDA sent a letter September 13th, 2012, and November 20th, 2012, to the company, basically trying to work on them with their 510K, saying, you have to submit more. This is inadequate. We don't have those letters, but that's what those letters say. And what the company said, what the FDA said was 23andMe failed to address the issues described. Now, this is where 23andMe went really wrong, I think. From May 2013 up until November, there had been no communication from 23andMe with the FDA. None, according to the FDA. None. They didn't go back to them. But what the FDA saw was that the company went out and actually started a marketing campaign to expand what they were doing without 510K clearance. So the FDA does not like to be trifled with, and they said, okay, we worked with you, and now we're bringing down the hammer. And this is not the biggest hammer they have, but it is a definite hammer. the fact that we all, or many of us know about exactly this situation tells you the impact these warning letters have. And what the FDA told them was that more than 5 years after you began marketing, you still had not completed some of the studies and had not even started other studies necessary to support a marketing submission for the PGS. Now, keep in mind, this is a product that was on the market. I mean, people were using this, and it sort of tells you where the FDA came from. I don't think the FDA quite knew how to handle 23andMe. It's, again, an example of a novel technology, a novel way to do things. And if you're going for 4 years or some portion of that with a product on the market that has not gone through that FDA process, you can tell people in the FDA were scratching their heads saying, can we really go after this company? Is this something which falls under our regulations? And apparently they said, yes, it does, finally, and they sent out this warning letter. Now, what did 23andMe do? Well, they immediately discontinued marketing until FDA authorization. The FDA said that the products were adulterated and misbranded. They said these products are adulterated and misbranded because you don't have either PMA approval, 510K clearance, you haven't done an IDE, that's an investigational device exemption. Basically what that is at the beginning when you're going through those human trials, the FDA realizes, hey, you have to test this stuff in some humans. That's called an investigational device exemption. You're not marketing mass marketing, but you are using it in certain centers in the country to establish your safety and effectiveness. The FDA gave 23andMe 15 days to respond, and 23andMe then did respond, and it announced within those 15 days that it no longer offers health-related results from its genetic tests. So it stopped. What happened the next day? A class action was filed. So you see how somebody gets into hot water, and I think that their problems are really ongoing. They've obviously invested a lot into these products, and they see that there's a lot of demand for them. The FDA also sees that, but they're going to go through the correct process, and the FDA has made that pretty clear now. So that is 23andMe, and I have one more, and it's even worse. And again, I only raise it because it is along the lines of new technology. Oh, and one last thing on 23andMe. People from the outside, I think, look at it and say, this is a company that just didn't know what it was doing. It was a high-tech company that was used to just being able to put things out of the market, or that's the realm it came from Silicon Valley, and didn't really realize there was all this regulation. If you get into the facts, they knew there was regulation. It was just uncertain regulation. So I think they probably were trying to comply. They obviously went through a lot to try to comply. They didn't. So I think that what you see in the press, that maybe they just didn't know what they were doing. I think they were probably getting very high-level legal advice on this. And their lawyers, although I don't know this, they were probably telling them, you're in an uncertain area. So finally, the last one is a dietary supplement case. And I bring it up only because it's something that sort of, it's a company that arose from novel technology. At the time, it was a company, probably one of the first ones that started marketing dietary supplements, bodybuilding supplements over the internet. It's a company called bodybuilding.com. Made a lot of money. There were a couple of guys who built a $750 million, $800 million company within about 4 years. There was a lot of demand for these bodybuilding supplements over the internet. Now, what slipped in there were steroids. And they were basically selling products, dietary supplements with steroids. And I just raised this. I don't want to get too into it. But this is just an example of the FDA powers. The FDA started first sending out warning letters to the manufacturers who were putting their products on this site. They're small fish. They then went after the bodybuilding.com. And I've actually sat with one of the guys who was in this raid, and he had very explicit memory of how awful it was. The FDA, when they come in, and when they do something really extreme like this, you can tell that you will see they have the power to do it. They coordinated this with, they did it the day when one of the two big, huge bodybuilding competitions went on across country. So they knew that the high-level people in the company were going to be gone. They went in, and they descended with about 35 agents. And the people who were there, the highest level was the guy who was in charge of their compliance. That was the highest level. No CEO, no president, no treasurer, no legal counsel. That's the guy. A guy who had put in charge of compliance about a year before that. And they seized. They took computers. They took personal computers. They took laptop computers. They seized product. And then finally, their lawyer, who got a call, went in there and said, and they were actually questioning people, and the lawyer got in there then and said, yeah, stop, you guys aren't saying anything anymore. But that was something that already happened. They had already said things. So what did bodybuilding.com do? They listened. November 2009, they recalled 65 products, followed with a federal investigation and prosecution. And in May 2012, the company and the former president pled guilty and paid fines. So that's sort of the worst case scenario. So I just wanted to give you that one. That's it. Thanks.
That is a worst case scenario. Well, I'm interested in our two technologists now sort of responding to these regulatory regimes that have been so beautifully laid out. And I guess there are sort of two directions and two issues that I guess I'm interested in hearing about, and I think our audience as well, is first, when you're seeing these regulatory regimes, how you think they impact sort of currently just the technology as it exists in the sort of businesses that are now trying to be created. And then also, you both have a sense of the direction the technology is going in, and then how this regulatory regime needs to change and be shaped, particularly as you go through this potential for this kind of radical decentralization of the manufacturing processes. And so I guess and obviously you know so much more about this than me that if there are other things as well, but we've had such a nice portrayal of the regulatory regime. I'm kind of interested in how you both respond to it. So Andrew, let's start with you, and then we can go to Keith.
It's pretty fascinating because I come from a world like Keith. I had some experience with Amgen as well. I spent 7 years with the company in research, less on the development side, but it's kind of hard not to be aware that you're working for a major biopharma and that FDA compliance is a big part of it, and certainly our legal teams at Amgen were excellent. But my philosophy, what I learned at Amgen too, was that the process of bringing a drug to market, as you know, is a long and complicated process. A medical device might be a little shorter, a diagnostic might be a shorter process, and certainly I've just learned some of the other classifications and pathways for bringing devices to market. But certainly in the world of drug development, as we know, it can take 10 to 15 years and upwards of $1 billion, depending on how the accounting is done. That to me just didn't resonate well. I'm someone who came up through the world of bioinformatics, where you can sit down and write a computer program and analyze data very quickly. With DNA sequencing, for example, the foundation of ultimately 23andMe, this was a technology that was moving incredibly quickly. As we know, the Human Genome Project was launched in 1990 and first draft completed in 2000, a decade of massive technological shift that didn't just open up the human genome, it opened up the genome of every organism. And we're still dealing with that today. So just the idea that we had these rapidly increasing technologies and capabilities with computing, DNA sequencing, et cetera, didn't really fit with this long development process for a new innovation in medicine. Another technology, just in general, when things get digitized, when things get turned into ones and zeros, and suddenly we can amplify them with virtually no cost, transmit them at the speed of light. It takes a millisecond to send a file around the world. What we've seen in general is an acceleration of the creativity and exploitation of the space. Because now you can share and collaborate with much less friction, which is kind of cool. The rise of the web, just in terms of email and communication, has increased productivity and creativity globally. When it's tied to economy, then you get some really interesting things, especially, and companies are struggling with this. The music industry and the movie industry, as things got digitized, struggled with how do they protect their intellectual property and content, distribute it. A lot of companies that made digital products, Microsoft operating systems, for example, they knew their products were priced for certain markets but could not be afforded by the majority of the world's computer users, so they tolerated piracy of their software as one byproduct of distribution. You know, as long as their core economy was secure, they could afford some piracy. These are really different dynamics to any other physical good. What's interesting here is, for me, at least as working with a software company, we make design software. That's like, you know, we don't make the product. We make the tools that allow people to make the product. You wouldn't necessarily sue the company that made a wrench, you know, if a car that the wrench was used on was in a car accident. I suppose you could in some cases, but there's a lot of creativity in law too. But it just doesn't seem appropriate. So we make the design tools. How people apply those tools are really different. So there's a difference between the tools for creation and then the content. So really, for me, it's how do we manage the digital content that's really going to be important. Because if everyone's got a printer, then the printer will have some IP around it, et cetera, just because it's a physical device. But the printer isn't making a medical device. Ultimately, there's a content file that was created by a creator. There's a whole chain of events, a designer, a design, that ultimately gets translated to reality and then move forward. I move pretty flexibly through this process. I consider myself a designer. There are certain tools to turn that design into a digital file. There are certain tools to take that digital file and actually make it into something physical. But even then, just because it's physical, there's certain rules to bringing that to market. And I think we're in a brand new space here.
But Andrew, in light of the brand new space, you talk about how, within the community of folks who are in software, who are used to the sort of speed that you talk about that's generated by just digitization, what do you imagine the reaction would be with the sort of realization that the best, or maybe the only locus for actual regulation of really decentralized printing of any type of device is with the software? Right? I mean,
with
that,
the content or with the design software?
Well, I guess it's with, frankly, it sounds like the government would be struggling with both in trying to figure out where best to regulate. And that seems like a clash of culture that would be sort of profound. I mean, you're sort of used to working in environments that there is so much speed. To have the government inserting itself into the process of software production in that way. I mean, how do you imagine the community would react?
It's really difficult to tell. In the world of software, we're used to being able to pretty much write whatever we want and drop it on the marketplace. There's very few software applications that really come under a lot of scrutiny. I'm familiar with the developers of UCheck. UCheck is a simple application. They didn't develop the medical technology. It's actually a urine dipstick that's used in hospital diagnostics and has been for 30 or 40 years. It's just that you have to visually look at it and compare it to a color chart on the side of the tube that comes with the dipsticks. Making a color analysis system with your iPhone actually seems like a major improvement to interpretation. So for me, we don't have all the answers. Obviously, the FDA doesn't either. What I see as being probably the most challenging part of this is because medicine's becoming more and more digitized. The case of 23andMe is telling, because really we have a digital program in all of us, our genome. The technology that has been brought to market to read those genomes is pretty much available to anyone now. ubiquitous. So there's nothing stopping me from getting my genome completely sequenced. In fact, I did that last year. It cost $4,500 at the time. And then the interpretation of that sequence by 23andMe with a few markers, which, by the way, the correlations are made by scientists all around the world. It's not that 23andMe did any of those correlations. They just processed the input data against the findings that have been published by the scientists around the world and put it in a graphical interface. But this interpretation is ongoing, and it's not definitive. So I don't know how that works. So that's just reading and interpretation. I'm actually more interested in what happens when we start writing. You know, for example, in the same way that this is a 3D printed molecule, or, you know, of a virus, you can basically make the actual particle. So what happens when the tools of creation actually allow the direct production of a medical device? You can say a crutch, that's great. But it's the same principle. What happens when it's a cancer medicine? And once you've made that digital content, even if it's just for, you know, for fun, just as a hypothetical exercise, once it's digitized and put up on the web, now someone can go print it. Well, someone can go use it. So I don't know where to put in the appropriate checks and balances. Yeah. We know in that world today, with at least the DNA synthesizer, kind of a molecular 3D printer, we have a select list of things we should not print.
Right.
So like those companies that do that molecular printing have a list that says, do not print this content. This is a toxin, this is a dangerous virus, this is something that we do not want to see translated from the virtual to the real.
Right. Well, that's a great segue, I think, into Keith, because since that's ultimately, I think, sort of printing a heart is something that I think obviously is socially beneficial.
Right.
And so I'm interested in how, you know, you see that interaction with the existing regulatory regime.
Yeah, let's work on a spectrum, starting from maybe the creation of devices that are aligned with current technology, but just using a different new method to create it, and clearly working towards just correcting disease, towards this other end where it's, you know, you're trying to create something new and working in a new area of technology. So I would say, I would break it down in terms of how I think about the regulatory interaction a couple different ways. Let's start with the creation of medical devices, just defined as plastic or metal pieces. And I know that's a narrow definition, but that's certainly where 3D printing can work very readily already. We saw the example that Kai gave of something that was approved. And I think within the 510K regime, you have a pretty clear pathway. The regulations as they exist are pretty well set up to allow for production of those medical devices with predicate devices that already exist with a higher degree of customization for a patient. So you can take their direct medical imaging data, put it into a CAD, into an instrument, to print something that is a better section of skull to replace something that's missing, is a better implant to the bone to create. And eventually we'll get to better knee and hip implants, things like that, that are more directly proportioned for individual patients and personalized in that context, but that we're going to largely have materials that are within a box that is similar to the existing medical devices that we've already produced, and that's why there's a low safety delta in terms of things that have been done in the past. That's why you can follow a 510K for the most part. So I think in terms of medical device in the context of plastic and metal replacement parts and things like that, I think there's actually a nice path forward within existing regulations. And I think that does reproduce to some degree inside tissue regulations as well. So as Marsha laid out, it's a little bit more complex on that side. You know, when you're building something that's made of living cells, there's a layer of difficulty in terms of FDA assessment of that. I agree with the statement that there's not really a 510K pathway there. You're going to need pre-market authorization. You're going to do a full set of clinical studies to prove something works, presuming that you're starting with, you know, the premise that you're building in a centralized lab for a large number of patients. And so in that context, the one comment I would have on the existing regulatory scheme is that in all of my experience with the FDA at Amgen before that and since then, the FDA consists of intelligent, well-intentioned scientists who want to work with you. We've seen examples of them moving hand in hand with industry and to move things forward quickly. That's generally the tenor they take. So I think that their biggest limitation today in terms of 3D bioprinting is actually their current structure, because as Marsha described, there's a little bit of a interplay between multiple agencies, between CBER, the biologics group, and the CDRH, the device group, where it's not clear where things are grabbed at first. That creates uncertainty for companies going in. That creates uncertainty for investors and limits investment to some degree. And it stands in contrast to Europe, which has already created a center called the Advanced Medicine, what do they call them? Sorry, ATMP, so Advanced Technology Medicinal Products. That's their center for regulating anything that consists mainly of a living cell that's going to be given as a medical therapy. And so that includes cell therapies, which are either injected as a suspension or otherwise, and it includes tissues. What they've created there is a center for knowledge perpetuation across groups inside that when they're reviewing different products that does speed things. And a lot of US companies that are working in this space actually start their clinical trials today in the UK and Sweden because the regulatory pathway is more efficient. It's simply more efficient. That doesn't mean that the FDA doesn't have the good intentions, as I said, on this side. I think it means that they have just the way that they're constructed, their hierarchical construction does not yet allow them to be as efficient, and I think they can move towards that. We have, Organovo, we have regular meetings with FDA in terms of sharing information with them about how we're progressing, just because we get invited to do that, and they do offer methods for interaction with their scientists. People meet with them regularly at industry conferences. They send people out. They often have workshops in Bethesda because their budgets for travel are a little bit different than most companies. But they really do engage well. And in reference to maybe some of the examples we saw up here, my take on how the FDA interacts with people is a little bit different than I think you see play out in some of these examples. I guess you guys think about the law, as Kai said, maybe sometimes as it's the set of rules that we abide by and the set of codification we've come up with, and if we follow that, then we're okay. In these emerging areas, because there's so much uncertainty, I kind of have changed my conception of what the law is in some sense, and I think of the law as the toolbox the prosecutor uses once they've decided you're malfeasant. So in the absence of law, I don't have the ability to understand where I can operate. And I give my folks the guidance that our goal is to never be considered malfeasant, right? We don't ever want to be across any border that doesn't even have to do with the law. It has to do with ethical and the overall, gestalt that they're going to look at us and see how we're behaving. And I think that's what you see from 23andMe. The FDA didn't even know where they fell in terms of the law in the early days of that. They were working with them for 4 years trying to figure that out. But they certainly knew when they had crossed the line with aggressive marketing and got out there and started to oversell and overstate their case, and they made their point when that happened. That's actually how I think the dividing line often comes, marketing. That step where you take to be aggressively marketing something is when you can attract the attention of the FDA, and that's appropriate. When you look at the potential impact of any product or anything that we're putting out there from a medical perspective, you cross a threshold. And the 38 Act that Marsha reviewed, the first the act that created the FDA, actually was a result of something where we crossed a certain threshold in terms of our potential to impact a wide number of people. There was an incident called the Massacre Incident where before that, we had basically one-to-one pharmacy compounding of all medicines. So you had a prescription, you went to the pharmacist, they made you up a dose, and you took that home and you took that dose. We didn't have centralized labs building things, but that had started to happen. And someone compounding what I think was ethylene glycol, the monomer of essentially antifreeze, but it was used in preparations. They made up a batch of polyethylene glycol that went into 10,000 children and had substantial impurities that caused them all to become sick. That's what crossed the threshold into becoming something that you wanted a government centrally to regulate, because you had the potential to influence a ton of people and make them sick at once with one mistake made in a central lab. And that's where I think we have to evolve some of our thinking to get to. So if you go back to the tissues, I was talking a lot about how it fits into the regulatory scheme we have in terms of FDA. You go through clinical studies and you move it forward. But there's a chance that things move in a different direction. As you move forward, if you think about taking a bioprinter, and I think as Marsha would say, you would have to, of course, regulate the bioprinter as a device before it goes into a clinic and can sit there, because it has to perform to someone's expectations. But once you've done that, how do you regulate how it's used in that clinic? And if you're preparing something for an individual patient, short of the FDA, expanding its resources tremendously, how are you going to be able to watch over everyone working in every clinic in the United States when they're using some end product like this? So I think it becomes a slightly different scheme that we have to think about. How would you regulate personalized medicine at the bedside with something like a 3D bioprinter? And this is a very active area of the law right now and of FDA regulation, because short of bioprinting, there are folks who are using cell extraction instruments that are FDA approved. But if you go and look at how those are being used, and they're used in various different ways by medical professionals, by MDs, in ways that we might think of, if they were happening in Mexico, we would think of them as medical tourism. But they're happening at Stanford. They're happening at Cedars-Sinai. People are paying for these procedures in the United States with completely ethical medical professionals conducting them, taking cells out with a regulated medical device, but then using them in a procedure that no one's evaluated in any sort of thorough clinical testing. One example of that, and this is actually more prevalent than I realized, is actually breast reconstruction, not augmentation, but reconstruction after breast cancer surgery. There are instruments that will take out fat tissue, and people have developed ways, individual medical professionals, MDs, clinicians have developed ways to use those to do breast reconstruction in a very positive way for a cancer patient, and that's a very good thing. And we can make a mistake in building a regulatory schema that's too restrictive, because when you go back and think about it, we didn't invent coronary artery bypass surgery with a company working in Indianapolis applying to the FDA to get that out there. It was invented by doctors individually without restriction, and then eventually perpetuated throughout the medical profession. So we have to allow for some level of really almost Darwinian entrepreneurship in the medical profession as well.
Well, so what's fascinating about what you just described, Keith, is the way that, to the extent that the current regulatory regime, which was a centralized regime, was generated by a transformation in the industry, right, of centralization of manufacturing of pharmaceuticals. And what you've described and what Andrew has certainly alluded to is the potential for a decentralization happening once again. And one of the first reactions I have, and I guess I'd ask this to sort of each of the panelists for a sort of brief answer, and we can start with Marsha and come back down, is does the fact that you have that kind of decentralization mean that actually you could conceive of a regulatory regime that itself becomes decentralized, right? That if part of the problem is this focus on a centralized bureaucracy that you have to go to that is itself resource deprived, and that can slow down the process. Whether some way of decentralizing the regulatory process. I mean, look, we don't all apply to the federal government to get our driver's licenses, right? I mean, we have this regulatory regime that is bureaucratized and is designed to move more quickly. I'm not quite sure what the equivalent of that would be for something like, in organs or the type of procedures, but you do recall, right, driving is potentially incredibly dangerous, and it's also incredibly socially useful, right, and that's kind of similar to what you're talking about with these products. And so I'm wondering if, as I sort of go down the panel, whether we could conceive of a decentralized regime that would be faster but accomplish the same purposes that we would want with a more centralized regime. So, Marsha.
Yeah, well, there's already a lot of this that goes on now in this whole health world. The FDA's jurisdiction is limited to things that are crossing state lines or that are in commerce. And one area that surely you're familiar with, drugs are approved by FDA for particular uses, but physicians use them for what's called off-label uses, for uses that have not been proven safe and effective regularly. Some drugs are used way more for off-label uses than for on-label uses. This does create some issues at FDA concerning the marketing of these and whether companies are getting something approved for the little use. And then, because the big game now is if you can get something approved for what's called an orphan drug use, you get increased, you make a lot more money out of that in terms of you get patent-like privileges for a lot longer. And if it is used then for something that is not just suffered by 200,000 people, but by 50 million people nationally, that is a home run for your investors, big time. So this has gone on there. What's the control over this? If physicians are using this in ways that are not supported by at least information that's coming from reputable sources, and they harm someone, it's medical malpractice. The states govern who is a physician and what's being done. So that's one area of control. Another area where we've had decentralization, that there's just as of December some greater centralization. In the pharmacy world, pharmacists have in the last mostly 2 decades gone on beyond what's called traditional pharmacy compounding, which is to say to take a drug that's out there and make a slight change in it so that a capsule could become a liquid so that people who can't swallow could take it for an individual. And this has been regulated by the states, but companies have gone into the bigness of big-time compounding, advertising it. A law that passed was then dinged by the Supreme Court, and it was not clear whether any of it was still in existence because it came up against a First Amendment issue that the FDA has been running into regularly. And a new law passed to require regulation of these businesses as outsourcing wholesalers. There's a whole new category for them in federal law. So that was, it was being done in a decentralized way, but crossing state lines. And like most everything that happens in getting the Congress to give power to FDA, there are bodies on the floor. There's been blood spilled. In that case, it was the Massachusetts compounding pharmacy whose products killed people across and injured people across the country. And everybody said, oh, whoops, FDA's not paying attention. FDA said, because we're not really sure we have statutory authority anymore. Oh, whoops, we need something else. So they created something. So unfortunately, it has regularly over time taken dead people to cause the notion of we got to control this better. So surely there's going to be those risks in bioprinting as well, and the central versus the 50 states, some of which are doing this better than others, is a push and tug.
Yeah, and just a quick comment off that. I think that industry has a real interest in a proper regulatory schema because we recognize that a too aggressive regulatory schema from the start limits us, but that if it's not appropriate and you have one of these major incidents, the setbacks are much larger. An example there was, gene therapy in 1998.
Yeah.
There was a clinical study that was done that killed someone who had a disease that was very tolerable over a lifespan with an attempt to cure it with gene therapy, and that field was set back for a decade because the FDA wouldn't do anything else and put anyone else at risk.
Kai, what do you think about?
Well, in terms of decentralization, I guess the question is, what are we talking about in decentralization? In the medical device, pharma, bio world, there are actually some nice controls in place already, assuming that there is some regulatory process and that doctors are the ones these are decentralized to. That's actually a good thing. There's a certain level of competence that's there. If the decentralization is a doctor at Stanford who is trying to do something groundbreaking. I think one of the things, again, with what Marsha said is doctors do that all the time. Off-label use is legal, it's encouraged, and it is something that's seen as driving medicine forward. These doctors aren't out there trying to make billions of dollars. Well, some of them are, but at those initial steps, they are not. They're trying to treat somebody, and they're using their incredible minds to do that. So it's something that we should definitely encourage, and the FDA will never get into off-label use in that way. They don't have the authority to do it. But that brings me back to who are we talking about as decentralized to? 3D printers and how are they going to be regulated and exactly what is being regulated. And that brings me back to, again, okay, is it the product? Is it the software? Is it the actual printer? And for different ones, it may be a different answer. That's something that I think is very important to hammer out next, and something the FDA has already said. They fully realize that. For the FDA, moving quickly, what they do is they put out these guidance documents, and they will tell people, okay, generally in this area, this is how we think you ought to proceed. Now, for the FDA, quickly putting out a guidance document is 2 years. And for people who are in business and trying to develop things, that's not necessarily a satisfactory answer. And again, they are forced, as Keith, I'm sure is, to go forward in the face of uncertainty. Get the best legal advice you can, and then work within that gray area.
Andrew, what do you think about what Kai is referring to of this sort of problem of eventually, perhaps one of the goals is decentralization to an extent where you can't just guarantee that the only people it's being decentralized to are experts at Stanford's hospitals, but instead can be decentralized to any doctor in the United States or any patient in the United States, right? What's the appropriate regulatory response to that? Or
I don't have
right.
I don't know what's appropriate. What I know is instead of just regulating products, the FDA is going to have to become much more embedded at regulating processes and doing it in real time. Right. So I look at, as things get digitized, again, borders fall away. They're just gone. They don't matter. You know, we're still struggling with local versus global. You know, businesses have adapted over the last 30 years to become global enterprises and have leveraged, you know, some of their practices to maximize efficiencies there and benefits for the companies. Regulatory agencies and governments and these groups, they act locally. And it's very difficult for them to move. For example, with just going back to 23andMe, nothing would have stopped 23andMe from incorporating in a different company, and now you just send your spit sample somewhere else. Like it's not that difficult to get around FDA regulation because it's U.S. based. Granted, other countries may follow it or work with different organizations, but the point is once you have a digital design, it's easy to transmit, and released once, you can't recall it. Like it's just going to keep going out there. So you know, and designers working in digital space can work from anywhere. That's assuming they're actually a human designer and not just an algorithm that's taking data and actually auto-generating designs. So design software and the content are pretty much universally available anywhere, or it could be reverse engineered, modified, get around. So I think the FDA is going to have a lot of trouble there, except looking at an entire process. And the printers themselves, again, a 3D printer can go make a troll, maybe a patent troll, or you know, an actual medical device. So I think you know you just can't look at it in isolation anymore.
So when you say the process, elaborate a little bit on that, about what you mean by that.
Yeah. So I usually describe, for people that aren't familiar with 3D printing or molecular printing of the DNA molecule, I usually say, look, let's just take it back one generation to 2D printing. 2D printing was pretty transformative. It's when
so I've heard.
2D printing, really the big shift was in the 1980s when we suddenly got word processors and printers sitting on a desk instead of a person and a typewriter and carbon paper, right? Like this was a big deal. It revolutionized desktop publishing and across the board. Really, Autodesk was formed in that milieu because they just used high-end workstations and took 2D blueprints and made them into 3D, you know, digital blueprints, 2 and 3D digital blueprints. Like that was the birth of it. So really, it changes the speed at which you can do things and how you can collaborate and share information. It's really just the same thing in 3D now. Like it says disruptive. It disrupts the old businesses. You don't see typewriters anymore, and the processes, and creates new environments. But at the end of the day, all it really does is accelerate innovation, because now more people have access to the tools of creation and distribution and economy. So I think we're in a noisy period. Because we're learning how to adapt this, especially to some really old and creaky processes around medicine, which, by the way, I think are fundamentally in trouble. You know, we don't tolerate 15-year knowledge cycles anymore. Like, that's crazy. We're all hyperactive ADD, and if not you, then your children. And like, they're going to say, what? You know, I have cancer and you can't treat it? What the hell is the problem? What have you been doing, people? Right? So they're going to seek solutions no matter where they pop up in the world. We can hop on an airplane and go anywhere on the planet within a day for pretty much $1,000 today. Do you really want to cripple your R&D architectures, your economies, as these things become more digitized and print on demand?
But what that suggests, and I guess, Keith, I wonder if you have thoughts about this, is that ultimately, if you take that to the extreme, then the only regulatory regime that can survive in that context is just the market.
Well, no,
right?
It's actually an automated, real-time monitoring system. Look at Twitter. That revolutionizes journalism because it's real-time information, which can be aggregated and processed not only by the company Twitter, but by anyone that buys a Twitter feed. So I was fascinated when the World Health Organization was essentially shown up by Google Flu Trends, and you know, where they could predict where the flu was 2 weeks in advance of World Health, you know, WHO. Well, okay, well that's great. Now there's groups that have specifically built engines to monitor for outbreaks, et cetera, and now they can get that down to days. So real-time monitoring is cool. You're all a clinical trial of one. But if you're being monitored, you know, for however you're doing it, you're self-reporting, the virtual clinical trials are really cool. You know, what happens when it's just automated data generation and it can start to predict that you may be, you know, have a 95% likelihood of having a heart attack this week, you know, just because of, you know, your changes in activity patterns or some blood monitoring automatically. So I think the key is, how do you build monitoring into the process and really take it to, you know, distribute it, take that from, you know, at the start. Do we need a global FDA? Let's put it that way.
Right. Yeah.
Well, and I can comment, I think, on you know, how we set these regimes up a little bit. I think one thing we have to start with is an understanding that there's no perfect regulatory regime that's going to restrict individual action. There's just no way. We can't stop use of illegal drugs. I mean, forget it. You can't, if you think about something closer to you know, the medicine, we can't stop the spread of performance-enhancing drugs and use of those off-label in negative ways. And although a lot of the times we think about that as, well, simply helping an athlete so there's no harm done, you know, at one point the entire Dutch cycling team nearly killed themselves because they took so much EPO, their red blood cells nearly clogged their vascular systems. So, and that happens, I'm sure, in high schools where people are taking HGH to their own detriment to the levels they take them and things like that. So that, you know, we have to accept that at some level things are going to happen, and we can't, as Andrew's kind of hinting at, we can't slow down an entire industry for that. We have to address those issues as they come up. But there are ways to think about the, you know, regulating the benevolent uses of these, I think, in better ways than too centralized control. And one thing I would point to that we have to consider is not just a central regulatory body, but who are the partners to the central regulatory bodies that help them do their job that are perhaps more local. An example would be if you go and think about how blood supplies are regulated in this country, how the transplant of human organs is regulated. These are done through non-government organizations, things like the American Association of Blood Banks that will license and certify centers. The FDA has rights to inspect blood bank centers through, I think, Public Health and Safety Act, and make sure they're up to code in a way they would inspect a pharmaceutical manufacturer, and they do that. They conduct inspections, and they should. But the day-to-day operations of those, the processes, as Andrew points to, are actually regulated more by an industry group, a group of peers, and that is a partner to the FDA because they can say, if you're certified by the AABB, we know you're doing a good job, or we can have reasonable confidence that we don't have to come after you until we start to see signals from them. And there's examples of that in other industries. You know, you think about the MPAA, you know, we've never legislated around movie ratings. If you think about the SEC, today more than half of their job is done by FINRA, which is the Financial Regulatory Authority, which is basically broker-dealers who partner together and form a regulatory body, a self-governing regulatory body. So I think there are ways that this has been done before, and so I can easily see groups like the International Society for Cell Therapy, who are already working towards these kinds of things. You know, if you create accreditation processes through groups like that, we can actually get to the point where FDA has to come in on the problem areas, and some of the more common areas of use can be centrally licensed. The one other thing I would say is you can think about the types of licensing that they could do is, you know, I think one thing I've described a little bit is the use of something like a bioprinter in clinic by an MD to do something. And I think there are a ton of MDs who are already doing stuff like that in animal studies, right? They're not necessarily doing them in their patients yet, but there are certainly tissue engineering MDs out there who are building things like trachea for their patients on an individual basis to treat that patient. I don't see that as ever a problem. Again, you have to watch, when does that cross over into, I'm marketing this broadly because I'm trying to bring in a ton of patients. But in doing that, maybe in the future, because you're not going to have that many individual medical professionals who can do that, maybe you have to think about licensed technicians that work with them and licensing those through central agencies where they can run the bioprinter under the MD's direction, but that MD doesn't have to be the be-all and end-all of knowledge and be able to make everything happen themselves.
Right, and that's, Andrew, that's process, right? Yeah. That's looking at different points. Great, well, so I want to be sure we have time for questions, but I'm just going to stand up here for a second. I promised that I would let the panelists, that we'd move away from sort of just talking about regulation and towards if you could pick something that the government could do that would be most positive in furthering the sort of interests that you're talking about here. And we've been talking about regulatory regimes, but we could also talk about intellectual property regimes or trade regimes. I was wondering if I could get all four of the panelists to just very briefly, because I do want to be sure we have time for questions, just very briefly, if you could just sort of say if there's one change that you think would be most useful in facilitating the sort of positive developments in this area. And it's mean to make one change, but that's because I'm the moderator, so I get to do that. I would love to hear what it is. So Keith, let's start with you, and we can go.
Well, we're going to learn about regulation here. I'm going to do 3 changes in the same time as I would do one. See if you can regulate me. Actually, very quickly, I think
I need my club.
We have something. I'll do it fast, I promise. We have something called the Valley of Death in our industry. In pharmaceuticals, if you create a good pharmaceutical and get it to phase 2, you don't need to fund it all the way through because a pharma will come in and take it. In our area, there's nobody there to take it because there's not a mature industry. Public policy to increase our ability to do more clinical trials at a reasonable cost to attract more investment would be great. Actually, I'll stop at that, and if we have time, we'll come back.
Great. Yeah, thank you. Andrew.
Really, the thing that for most useful for me is changing the mentality around mass marketing. Like mass personalization is a completely different game that requires different ways of looking at the problem and different ways of regulating it. Where certain points need a lot of attention because they're kind of common, a nexus, but really allowing, accepting that we are all different from the start, from our genomes, from our lifestyles, our behaviors, and that really trying to look at us as identical little creatures that behave the same way and come up with some standard process probably isn't the way to look at things today across the board. So for me, it's N of one drug designs. I just want to see anything that accelerates the ability to help others faster, and looking at processes to automate and speed that up, I think is fantastic.
Great. Kai?
I wish I had something more groundbreaking. I would say, I mean, I go back to, as a lawyer, tell me what I need to tell my clients. And I don't expect it to be black and white, but I need guidance to do that. And as it currently stands, often you'll get a question and you're left with looking at warning letters, or you're left with looking at a compliance agreement, or you're left with looking at court decisions. And that's not very clear guidance because it doesn't tell me what I have to or have to not tell my clients. It tells me what the FDA may or may not do. And maybes don't drive investment. If people are too uncertain about the regulatory regime and how you get something to market, the money, I think, has more trouble flowing in. And you see it, again, with that said, don't overregulate. Because I think what you see is it's very easy for the next Facebook or somebody to try to get money because it's a quick in and out. For medical devices, pharma, bio, it's more difficult because it's a much longer process. And anything you can do to remove the impediments while still giving clear guidance is what I'm looking for.
Great, thank you. Marsha?
And all lawyers don't necessarily think alike, but I was also thinking, and I know that FDA has a very small staff to deal with very big issues, and so they're hardworking, and there's only so much you can do in a day or a week. But if I could wave a magic wand and give them more people to do it, I really do wish they would move more quickly to guidance, and even beyond draft guidance. Really, just could you get the word out there? That would be really helpful. There's But right now, with their current budget situation, I know it's not going to happen. I just wish.
Well, that was so fast. I'm going to let Keith do his other two.
Well, I'll do one more here. This is actually, I think, an interesting one, so I'll put it out there. I would say the government needs to do more in cybersecurity for small companies. So we all know, if we've been keeping up with the NSA, that one of their current policies is to, when they find an exploitable security loophole, to keep it to themselves so they can exploit it and look into things. I actually think we need a different tack. I would say, as a cutting-edge company, that's working at the edge of an industry that is not tech, but clearly works with a lot of technology and information technology to store and warehouse our information and use our knowledge management, we're extremely at risk of losing that to hackers that come in because we don't have the underlying infrastructure to protect ourselves well enough as a small company that's starting out. I think that should be a governmental initiative to actually help small companies, protect themselves against the ingress of other countries.
Wow, that's great. Thank you. All right, well, we have two microphones, and again, I mean, I have a bunch of questions, but I would, if we crowdsource the questions, then we're liable to get more interesting ones. And in fact, just, I guess if you have a question, could you go up to one of the microphones? Although can I first do the Twitter question? Because we actually got a question on Twitter. And it's a perfect example, actually, Andrew, of sort of what you're talking about the advantage of the N of 1, because this is the sort of question that, with my limited knowledge, I would never have been able to even formulate. So let me ask, and frankly, I'm not even sure who the appropriate person to answer it is. So our Twitter follower asks, what impact does widely available 3D printing capabilities pose to utility models and petty patents in foreign countries? And what you can do, that seems to me to be a fairly specific question. But you could also link onto that just the issue which Andrew has alluded to of the sort of breakdown of national borders in regulating this sort of intellectual property generally. So I don't know who's appropriate to answer that.
It's a good question. Can you read it off just again?
Sure, of course. What impact does widely available 3D printing capabilities pose to utility models, petty patents in foreign countries?
I'm not sure what a utility model is. So.
Is it? I'm wondering if maybe the nature of the question is a little bit about how you can reproduce items that might be under patent, but using 3D. Is that maybe one interpretation?
Sure.
I mean, I think that's an interesting question to address, at least. I think it's hard. I think it's hard enough to pursue overseas intellectual property protection in many cases. I think we pursue a policy of pursuing patents in some jurisdictions, knowing full well that we will never enforce them, but perhaps we can sell the rights to someone who actually can in that country, who has the right partnership with government, let's say. It's a fact of life.
Yeah.
And And so, I think it's hard to think that yeah, if you're trying to create intellectual property, or even thinking about creating intellectual property that is a design, a code in 3D printing, how do you then try and capture on that? And I think it's very, very difficult to do so. So I think, it's actually the case, I would say, that I see the IP maybe future in this industry a little bit so in biotechnology, if you look back at the history, it's very binary results in IP. So you have Amgen with EPO. They won that patent. They were the first to get it, and it had a huge windfall for them because others couldn't reproduce EPO after that, and there were two close competitors. And that was a big deal. Myriad Genetics with the BRCA gene, even though we've seen some changes in how that's progressed over time, they were the first, and that was a big windfall to them. I think it's going to be quite different as we think about how 3D printing and 3D bioprinting evolve. The patent battles there that are going to employ folks in the room in the future, I think are going to be much more like, if you look at the battles between Google and Samsung today, between Apple and others, those are going to be what the battles look like. There's a lot more field out there. It's not about first, it's more about specific claims, and there's going to be a lot of trade-offs made in the decision making there, rather than absolute winners or losers on things.
I have to agree, and I think that it's going to be a spectrum of IP. If just looking in the digital realm, you still have patent and protected software, and open source as well, and everything in between. And of course, trying to do actual management of that IP in the digital space is itself a challenging and dynamic issue. So you'll stay employed.
And I would just add on the IP side and international questions of how you can protect your IP. Two countries are sort of interesting, some things that have happened recently. India, with pharmaceuticals, in some respects, I don't know all the details, but they really, they were allowing the government to come in and basically mass produce IP-protected, patent-protected products, and that created a huge uproar, and I don't think it has changed yet, but that's one example of a country that's doing something that really has impact on what their what their goal was to get medicine to their people. What the repercussions are long-term was the medicines won't go there, and not the way they want them to. The opposite example of that is China, and I'm not holding up China as a paragon of like IP protection, but I will say this: a lot of pharma and not, I don't think so much medical device, but a lot of pharma products are now manufactured in China. And I remember hearing FDA people talk about it in maybe 5 years ago, and they looked at a chart and they said that the FDA regulated, and where they go to inspect, I think there was about 95% was in the U.S. And then they showed another chart, which was that 95% of production was actually occurring in other countries. So that sort of tells you what the FDA and sort of this question of how does a national body really go international? It's difficult. But what happened now is the FDA actually does and is allowed by China to go in and regulate FDA facilities if they want to sell their products here. So that's an example of U.S. regulatory working in a way with another country where everybody sees what the bigger picture is, and everybody wants these things to advance for numerous reasons: health, money, all of it.
Great. So let's go to our questions. Yeah, sir.
Is this working? Okay. Could you inform us how the machines that manufacture medical devices are regulated today, if at all, and relate that back to the 3D printer, and maybe differentiate the case where the 3D printer is making a heart versus making braces versus sitting in a doctor's office making something in real time?
I think Marsha and I will probably comment on that. I'll start. It's interesting because I think there are a number of ways it can be regulated depending upon where it falls in the process almost. So when we think about the tissues that we might be building for transplant, I specifically think about the printer as a piece of process equipment that does not have regulation at the level of a formal application on its own to the FDA, but those pieces of process equipment are regulated as validated pieces as part of your application. So they have to perform to a certain level. The software on them has to be validated, i.e. much more bug-proof and code. The code has to be error-free, no crashes, things like that. You have to demonstrate that to the FDA for those pieces of what are called validated process equipment pieces. So I think that's how we think about it for things that we're producing centrally. But when you start to talk about then putting it into an end state, you know, where it might be, let's take something that's a different example. We're working today with Oregon Health and Sciences University, which has a cancer center, Knight Cancer Center up there. They're bioprinting tumor models that we believe will be useful in drug discovery and perhaps in diagnosis. So if those are useful in diagnosis, we could have a future instrument that is taking a bit of biopsied patient material, turning that into multiple little 3D printed tumor models, testing different drug regimens, and that becomes a companion diagnostic to the drugs that the doctor is going to give. That would be a highly regulated instrument that would be in clinic, in use, you know, at the bedside roughly, although the time frames might not be, you know, very short. So in that case, I think it's a highly regulated instrument that's going to be regulated like hematocrit machines are today and are pre-authorized by FDA.
As a medical device.
As I believe those are medical devices. Those clinical diagnostic instruments like hematocrit, not exactly. It's a similar law, but you don't do clinical trials. You just have to prove them out. So it's slightly different, but yeah, it's certainly regulated under the same act.
Yes, sir.
Thank you. Is this working? My name is Gordon Endo, and my question is raised because I think all of the panelists have talked about ingredients that would create a perfect storm, of particularly a problem for regulatory agencies. And that is, Andrew was talking about how the 3D printers, the proliferation of 3D printers is like laptops and then tablets and then iPhones or smartphones. I mean, I think 3D printers is the next big thing, especially if Apple starts to do something with it.
A very pretty 3D.
And then Professor Schiller was talking about crowdsourcing. An article that I read recently was of a man whose son needed a prosthetic hand, and he couldn't afford that. He was able to get blueprints, basically, for a 3D printer to create a prosthetic hand for his son, custom sized, for $5 over the internet. And it was basically crowdsourcing the blueprint. And it would have cost $20,000 or $30,000 to get that through regular medical channels. So I'm thinking that it doesn't take much imagination to think about how that could be parlayed into all sorts of other devices, and including organic materials. And how do you regulate people when all the material is and the content that Andrew is talking about is crowdsourced? Who regulates that? How do you put controls on that? How do you make things safe? How do you make sure that there aren't terrorists kind of coming in and hacking and trying to, contaminate some of those plans? What do we do? Is the FDA going to do something about it, or is there somebody else we can look to?
Goodness.
You've just provided the material for another whole couple of hours of and years of concern. I mean, that's obviously going to be a concern because all those issues are concerns. And some people are going to say, if I'm going to get my kid a hand, I want to know that it was an approved hand, that it will really work as it says it would, and not one, just as you can now. You can buy a lot of drugs on the internet, and they're not legal. And some have no active ingredient, and some may have some active ingredient, and some may have dangerous active ingredient. I mean, that's the issue. And it is very, very difficult to control, any of that. And just as in the whole central versus decentral, there are good actors and there are bad actors. There are even licensed physicians who are quacks in the sense of selling things that they have no reason to believe really work, but are making the money. So, this is not a new problem for society. It's just that digitizing makes it a problem that shows up more quickly and in more people's mailboxes.
But I wonder if our panelists, though, have the enormity of the problem and the beneficial things that come out of it are obvious. I wonder if the panelists have what would be sort of first steps right? In other words, that as this sort of new world emerges, you know, it's unfair to ask you to come up with the whole regulatory regime or lack thereof. But if you, again, just sort of incrementally, do you think there's something that can make sort of consumers more confident about what you might get over the internet, for example?
I have a few comments on that. I take most of my cues for what's happening in the digitization of life science from what I've seen in just the growth of the computer hardware and software industry. I think the dynamics are very similar, or at least I see them because they're human dynamics. The technology really doesn't matter. It's the human dynamics that underlie most of the stuff that we see as tools being used. And I think that as medicine becomes more digitized, the types of dynamics that we're seeing appear in things like you're alluding to with cybersecurity, the types of exploits that we're seeing in new business models, challenges and regulation in cyber get translated into kind of to digital biology, and you know, even to the digital files for medical devices, pretty much across the board, whether it's theft of information, modification, digital rights management, transmission, distribution. The whole world of software and hardware kind of exploded around us. The internet didn't come with regulation. It's kind of being added as we learn what the exploits and weaknesses are. I think we need to let go a little bit and let some of this stuff flourish and find out what the real problems are, who is getting hurt, what blood is being spilled, who, you know, is getting damaged, before we try and put it in a box and think we understand it.
Yeah, I think I like your example because it's an example that's a positive one, right? You're saying this person could be helped. And I think what we're going to find very quickly is that if people are being helped and regulation is standing in the way, we're going to very quickly move away from a regulatory issue to a legislative one, where people are going to demand the ability to do these things to help their loved ones, and that's not going to proceed very slowly. I think that would proceed very quickly. So I think we have to be aware that some of these technologies can be used for nefarious means. What I was trying to say before is I think that's going to happen to some degree, and I share Andrew's statement there. I think that we have to see what some of the negative things are. We can't be letting our imaginations run away with what might go wrong. We have to see what people's interests take them to. You know, there's been a lot of history of reaction to a new medical procedure that I fall back on. I mean, people used to think that using cadavers for medical research was completely unethical, but doing so saved a lot of lives because of the learnings, and very quickly people got that behind them. I think if we had categorical proof that an embryonic stem cell therapy saved people with breast cancer, there would be zero ethical dilemma about embryonic stem cells anymore.
I just add that to echo Marsha, I think that people's rationality does somewhat self-regulate, and if you're looking for medical devices or medical products to make you healthy, I don't think a lot of people are going to go to the internet to have a replacement heart, and then they couldn't put it in. But again, sort of along the lines of I don't want to make it too positive. I do like what Andrew and Keith are saying, and I do understand that there is a let's see what happens approach. But there are, as you say, there can be some serious repercussions. And if I don't think government will be able to prevent the means from getting out there, but I do think they have to be involved in that list of no's that you have. You said there's a list of no's of things I can't print out. And other people don't have that list of no's, and they don't care about that. Some people don't. And I do think whether it's the NSA monitoring things or whatever, especially in the U.S., it will be regulated somehow and monitored, especially on that really evil side you were mentioning.
Good. Next question.
Hi, my name is Peter Jensen. I'm a patent attorney, and I work on 3D printer patents down in Palo Alto. And so my question on the regulatory side is, in the 19th century, we had snake oil salesmen, and they'd go from town to town, and they could only produce so many of these little bottles, so they hurt a few people, but the information didn't really go from town to town, and they'd carry on, and as long as they didn't get chased down, they were fine. And then, you know, you have the ethylene glycol example, you know, where it's crystallizing in someone's brain and it's making them sick. When there was the industrialization of production, and then we had, you know, the Eisenhower freeway system, and you can distribute it. And then information got decentralized. We all started commenting on even things that had been FDA approved. You know, people on the internet, there's forums about whether they want to take the drug or not. Today, now we're seeing the decentralization of manufacturing into the home. And do you believe that actually one of the effective regulatory methods could be to now put the decision of whether you want to take that product or not back into the hands of people, and so the FDA could almost have like a sponsored, like Facebook type of profile for a drug where people could comment on it, and also you know, professionals could put up their opinions about it, but in the end it would be the choice of you know, it would be a very efficient market analysis of what drugs.
That immediately made me think of Patients Like Me. I don't know if you're aware of this, but it was a community forum that started up to allow people with illnesses that aren't necessarily managed by any one therapy today to share information, and it proved to be a really powerful forum. Yeah, I think that going along those lines is interesting, but I think there's checks and balances along the way. I think some things may fall into that very well. I think if it's a standardized mass market thing, not necessarily. Like if it's but as you start going into mass personalization, how do you know? Like how you have to run the system, you have to run the problem. So you have to give people the tools to report and to engage and to comment and ultimately broadcast their opinion. Today we find restaurants by Yelp, not by the advertising for the restaurant. You know, everyone gets a voice.
What do you think the you know, the FDA's role could be in fostering a system that gave, you know, really relevant and truthful information to the public?
I don't know what the process would be. All I know is if you're engaging with large, you know, potentially millions of people, that process has to be codified in some way and ultimately automated, because otherwise it just ends up noise. I don't know how often you read all the comments listed in, you know, a news article on Huffington Post or whatever, but it's like you can't, you find that that we're all really N of one, and we might have consensus opinions around certain things as a community or a nation, but it's a pretty wide spectrum.
It also, I guess, I wonder whether if you're doing a circumstance where if you're doing a model where it's that information is the sort of main regulatory tool, that one of the things that the state agency or the federal agency has to do is be sure that the information is representative, is to be sure that underrepresented groups and the information that is coming to them and from them, right? Because, I mean, these sort of information market-based ideas, it seems to me, need to recognize that there are going to be market failures of information sometimes. And the question is whether one role for the government can be ensuring that market failures of information don't occur in ways that create inaccurate conceptions of what a drug or a product is. Yeah, Marsha?
Yeah, the other thing is biological processes are not the same as saying something about, you know, I bought this.
Great cannolis at
Osteria or I bought this thing. You know, I bought this television, and it's lasted a long time, therefore it's very good. If you take a drug and you feel like you got better, first place, there's a gigantic placebo effect. That, you know, people are going to get better anyway. People, you know, don't necessarily, people have different genes. Some people were going to survive with it or without it. A lot of the information, testimonial proof, testimonials about whether a drug works or not have not been accepted as scientific evidence about that drug's working. So, and that would be true of a lot of medical devices doing what they should do depending on what they are. So, so sort of crowdsourcing the information. So the gold standard for biological determinations is a controlled clinical study where even the person doesn't know whether he or she has gotten the drug. And actually, there's some controversy, and there was a Wall Street Journal editorial about it this week, about FDA asking, in some circumstances involving surgery, they're doing dummy surgery because they really can't tell whether it really worked. Because all they're getting, because the information isn't clean, because we don't have a comparison group. So it's not an area that really fits a lot of other product areas.
I would just add that, and what's interesting, the regime you mentioned of basically mass marketing some things and the difficulty that the FDA has, I mean, it actually exists today with dietary supplements. And to get a dietary supplement on the market, what companies are supposed to do, and there are a lot of people running dietary supplement companies out of their garages. It is not your companies. I mean, they truly are, and they're trying to stay one step ahead of the law, or they are trying to build real businesses. And dietary supplements, all that people have to do to get something on the market is submit something to the FDA saying that I've got studies saying these are safe. They don't have to show they're effective. And if the FDA doesn't get back to them, I think in 75 days they can go on the market. If they don't get a letter saying you can do it, they just, if they can't do it, the FDA sends them something. The FDA doesn't have the resources to police all of that. And I think that's what you suggest could happen here. In that realm, and if the past is prologue, what we see is what the FDA has done is they will make select cases. They will get the bodybuilding.com people. They will get the guys who have reached critical mass so they affect enough people. And they will go after them if they need to. And on the regulation side, again, they can't police all of them. They police some of them, and then they try to make a big, huge example out of some people or some entities.
So we're almost out of time, and I see there are two more people standing up there. So how about this? How about you each ask your question as quickly as possible, and then we'll give our panelists a chance to respond.
So the core thing about 3D printing, right, is that it kind of democratizes production and manufacturing and stuff. And it seems like that with bioprinting, there's a whole other set of concerns there, like sterile materials and actually having bio-ink and vascularizing the organs or whatever else you're printing properly. I was just wondering if you could talk a little bit about like that tension and where you see that going. Like at some point, it's just going to be like build an organ tank that's kind of like the substrate that you build this stuff on, but it's just, it has oxygen and all the nutrients built into it, or where it's going.
It's a good question.
Actually, Keith, let me just get the other question.
Oh, yeah, sure. You're going to have them both. Okay.
Which is actually almost identical to what I was going to ask.
All right.
So I was actually going to propose a sort of regulatory scheme and see if you guys would comment on it. So as you mentioned, you aren't going to have someone going home and printing a 3D heart valve and installing and doing surgery on your son and putting it in him at home. You're going to do this, and you're going to have a doctor be doing this sort of level of high-end medical device use. So at that level, I was going to propose the idea of, right, we have a medical printer, validate it, just like you would have medical or the manufacturing device in the at biotech, whatever, validated. Then you're going to have a blueprint that's validated and available for purchase or use. And then you're going to have, as he said, the ingredients. You can't just have all the ingredients randomly. Everything has to be validated before you put it in any drug, any manufacturing process for this. Have all those things validated as cartridges that can then be installed into printers in the doctor's office. That would give us the sort of FDA oversight, because you'd have all three aspects here validated, and then you give the doctor the right and the ability to just sort of print what they need and use it. That was my first take on a regulatory scheme, and I thought I'd see if you guys had comments on it.
I can comment on that. Because I think you're going down a good line of thought, both of you, and I can connect them a little bit here by giving you maybe a little bit of a history of the current technology at Organovo. So we actually, I think it's safe to say that bioprinting is not a democratized technology yet. It's an enabling technology, but we can't hand it off easily to everyone. So I actually compare it not to a laptop computer, but to a punch card computing system. So the folks that have bioprinters that are not on Organovo's site are top academic professionals with lots of grad students to throw at the problem of making sure everything's working appropriately, like at the Knight Cancer Center at OHSU, at Harvard Medical School, places like that, but highly trained professionals and bioengineers who can work with things to make sure everything works. We're not at the point yet where we've got the sort of plug and chug. Now, when we think about how do you get to that, we go exactly where you just went, sir, which is how do we constrain the set of things that a bioprinter does to make it successful and reproducible in doing those things. And from an academic research perspective, we can still enable people to do a lot of things by saying, yeah, you don't have the perfectly flexible bioprinting system that can make everything in the world, every tissue you want. You can't just put whatever cells in it you'd like. But yeah, we have pre-validated cartridges that you can put in, and it's going to put those out, and you can work within a certain set of parameters where we have a more reasonable assurance that you're going to get something functional out of the printing job. And so I think that's where we go. Now, the problem with that particular setup in a clinical setting is actually that you don't have reproducibility on the input cells because they're coming from the individual patient in most cases. If you're not coming from the individual patient, then that can work quite well, but they have to be immune protected somehow, and that's hard to do. But it's that, and that's actually a big area right now for the FDA in different cell therapies that are autologous, which is using one patient's own cells. You're trying to come up with what's a potency assay for the patient's cells, if they're even going to work or not, and how does a company show that you're going to get the same thing from patient to patient? That's a challenge for people right now.
Andrew, and then Marsha.
Well, and I think that bioprinting, as you point out, it's in its infancy. It's an enabling tool, and the printers are still first generation. The software applications, I know from working with you, really are in very early stages as well. But we'll continue to see this grow and evolve, and because they're tools that we have some, again, we can prototype them and make them easier in part because of 3D printing. I think we'll see the tools evolve, and that will open up a lot of exploration into the space. And certainly for medical applications, yeah, validated across the way might be great. But if these tools can print a heart, it can print a pet. And I'm not kidding. And in terms of, like, already we make these little mechanical things using 3D printing. It doesn't take too much imagination to start thinking if we can just add one cell type, a muscle, maybe we can actually start making these things motile and innervating them with some cheap electronics. And so we're going to get surprised, people, a lot. And then in directly related to the type of stuff that we're looking at with FDA and approvals, I work with a type of 3D printer that just prints DNA. And this is a technology that's already exponential and is available to anyone on the web today. So anyone can do genetic engineering just with a piece of software and make real powerful genetic programs. We're companies, the whole industry is formalizing very quickly, but it's radically disruptive to the drug development process. And so we'll be surprised.
For the person with the regulatory question, I just have one question. What's the definition of validated?
Right, well, so we're out of time, and lunch is here. I want you to join me in thanking. This has been an incredible panel with incredibly thoughtful people, so thank you so much.